attorney will look to retain a qualified expert who can evaluate and assess the linkages between an SNP profile or a whole genomic profile and an STR profile. To be sure, an SNP profile or forensic genomic profile can't be searched in CODIS. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile. You would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile to then evaluate the reliability of the STR profile, the potential for any mixture, the potential for any artifacts in the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers would be.
Can I clarify something?
Sure.
So what you're saying is that you need to look at the qualified scientists would have to look at the SNP profile to compare it to the STP profile for reliability of the STP profile.
The STR profile.
STR.
Yes, so there could be clues, absolutely, that could be discerned from an analysis of the SNP or whole genomic profile. Because again, we're talking about two different tests of the same piece of evidence. And there have been, in peer-reviewed publication, I mean, one that comes to mind is Jae-Wah Kim, who published in the journal Cell about how an SNP profile can be linked to its STR profile. And that's by zeroing in on sort of the neighboring regions and examining those. So again, I'm not a biologist or a scientist, but I'm an attorney, who has a duty to investigate, and to investigate requires hiring experts to examine this data, this discovery that hasn't been produced yet. And so that's why the minimum practice standard is to get that discovery so that the attorney can then assess that discovery and then retain a qualified scientist to help understand the extent to which the SNP testing will shed light on the reliability of the STR testing that has already been done on the same piece of evidence.
Okay, so that having that profile on the SNP can verify the legitimacy of the STR.
Right, so that's my hypothesis. That's what I go to the expert to inquire about. Because again, this is a very much an emerging area of forensic science and litigation.
Sure.
And
Evolving.
Yes,
I'm going to object again. I don't believe that this witness is qualified to opine on what's needed in these scientific processes. He just indicated that it was his personal hypothesis. I would renew my objection, Your Honor.
Well, I'm going to overrule that because I asked the questions. I apologize. Go ahead, ask your next question.
When I'm talking about either the whole genome or the SNP profile, am I looking for just like a sheet of paper that has a bunch of numbers on it, or is there a packet of information that I need to go to my expert?
no, you need the raw data of the profile along with, it's similar to the sort of data that you obtain for the SDR testing. You get the raw data of the profile, you get the laboratory protocols, you get all the bench notes, how the profile was generated, but also you should get the discovery about how the profile was then searched in different databases and family trees constructed.
that was gonna be my next question. I heard you say that we can't look at this whole genome sequencing or the SNP in one category and then look at the building the tree to identify from the genetic genealogy piece, the genealogist piece, in its own separate area, that they're not two separate lanes that they combine.
Yes, they go hand in hand. You do one or the other. I mean, they go together.
Why?
I'm sorry?
Can you tell me why? Can you explain why you say they go together, why I need both?
Well, the SNP profile is what is searched in the ancestry database to then identify, potential relatives, and then family trees are built out. That's the object of the SNP testing. What's important to know from a defense perspective in terms of trial work and potential areas of cross-examination, the government is going to be introducing a statistic that is premised on the assumption of an unrelated universe of people. So what's the chance of finding a profile in a population where there's no relationship, relatedness between that profile and anyone in that universe? And so, as you know from talking about this whole concept of forensic genealogy, people who are related have similar DNA. And so the statistics change when you are talking about the chance of finding a profile within a related pool or related universe of individuals. And that's a legitimate area of inquiry on cross-examination for the defense to demonstrate the limitations of the statistical questions that the state is presenting through its expert witness. And to do that, you need to know, for example, who the population of related people are, because often from my work on the forensic genealogy, what I've seen is that when a match is found, when the STR match is found, then all building out, all further testing stops on the forensic genealogy side. And so it's important to know who hasn't been tested on the related person side in terms of developing cross-examination about the limitations of the statistical tool that the state uses in its case to demonstrate the rarity of the match that they're presenting.
Have you received genetic genealogy materials in your cases? I think I heard you say that.
Yes, so which wasn't surprising to me, because even though typically the government doesn't seek to introduce the forensic genealogy in its case, it nevertheless is evidence that is a scientific test of material in the case. And so the discovery rules typically call, for example, in Maryland, in the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either a materiality showing or that the item is introduced into evidence. And so even when there's a limitation on the item being introduced into evidence, that really goes to the item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
Just 1 minute. Thank you. Mr. Mercer, I don't have any other questions. I'm going to hang on just a minute to prosecute.
Thank you.
Thank you. Ms. Beatty?
Your Honor, I have no questions for this witness. Mr. and I will be making our legal arguments.
Okay, thank you. Okay, may this witness be excused?
You may.
Any objection?
No objection.
Okay. You're excused. You can now stay in the court if you'd like.
Thank you very much, Ronnie.
Appreciate you traveling.
Thank you.
It's been about an hour. Maybe I need to give the court reporter a break. How about just a short one? 5 minutes? 10 minutes? Maybe 10 minutes. Yeah?
Your Honor, that will give me time to have our next witness set up.
Okay, great. Okay, 10 minutes, and we are off the record.